My name's Ed Zaengle. I'm a geologist. Was educated at the State University at Oneonta, and I got an undergrad in geology and hydrology, and then I went to Southern Illinois, got a master's degree in geophysics, worked as an environmental geologist, overseeing the cleanup of hazardous waste sites for about 7 years across the country. Then went to law school at the University of Illinois, and then worked as a litigator, trial attorney in downtown Chicago for Jenner and Block and Wildman, Harold, Allen, and Dixon for about 7 years. And then I came back home because some of my neighbors who were farmers started getting letters and visits from landmen who wanted to lease their property. So that's what now I come back, and who I work for. I don't work for the gas companies. I work for landowners. Some of the farmers in this room, when they get an offer from a landman, I go in and I educate the farmers about the oil and gas leases and what each and every provision in those leases say and how they can protect themselves both from an environmental standpoint and a financial standpoint. That's what I do. Tonight I'm going to be talking about municipal authority to regulate oil and gas activities in a town. As we all know, you invite 3 lawyers into a room and ask them a simple question like, can our town regulate oil and gas law or oil and gas activities? And you're likely to get 3 different answers. And one of the reasons for that is because this is a relatively new area of law for New York State. And it's far from settled whether towns have the authority to regulate oil and gas in their towns. And what we're going to do tonight is we're going to kind of walk through the law and give an indication, one more slant, one more look to see what maybe some of the people on the other side of the advocates for bans and moratoriums might say about this issue. Don't kill the messenger. I'm just laying it out for you. Obviously, the town board, you guys have elected them. They are going to decide what to do. And I don't envy your position. It's a heated issue. And all we're trying to do is present information on both sides to help you guys make a good decision. What we're going to do, basically, we're going to discuss, does New York law provide local town boards with a legal right to place moratoriums and bans on oil and gas activities in their jurisdictions? Tonight I'm going to talk about things, when I mention moratoriums, I mean moratoriums and or bans. Okay, so I'll just be calling them moratoriums. What are the possible, and then the second thing we're going to be covering is we're going to be covering what are the possible benefits and risks to your town in passing a moratorium or ban. In order to do this, we basically have to look at 3 areas of law, 3 legal concepts. 1 is home rule, 2 is express preemption, and 3 is implied preemption. So those are the 3 basic legal principles we're going to be discussing. Home rule power, what is it? Well, basically that's the power that the state gives to local municipalities to regulate what goes on in their jurisdictions. Specifically, the New York State Constitution says, Constitution's home rule provision confers broad police powers upon local governments relating to the welfare of its citizens. So the first thing we know is it's very broad. This power is very broad. This grant of authority includes the ability of a municipality to enact local laws regarding the protection, order, conduct, safety, health, and well-being of persons or property within its borders. Now obviously, so that's pretty darn broad. But that within its borders is going to turn out to be a pretty important phrase. Because obviously towns can't pass laws that are going to affect the nearby town, right? That wouldn't make sense. Just like all powers, people give powers, they usually take them away too. Municipal police powers, however, are not unlimited. The state doesn't, the state likes to reserve some powers for itself, right? Under the doctrine of preemption, a local government may not exercise its police power by adopting a local law that is inconsistent with constitutional, that's New York or federal law, or general law. Well, what's general law mean? General law means statutory law, case law, things like that. Preemption can occur either by express language or by implicit language. So basically the state gives out the municipalities powers under its home rule law, but if it decides that it wants to regulate an area, then it can take them away. And it can preempt the state or the municipality from exercising in that area of law if it chooses. And it can do that by two ways. There's two ways to preempt. One, they can do it within the law itself by putting words in the law that say, we reserve the right for the state to regulate this area law. Or they can do it implicitly by placing regulations in place that would not work if local municipalities could also regulate in the area. So there's two different types of preemption, express and implied. Like we said, express preemption occurs when the legislature passes a state law or statute that expressly states that its purpose is to supersede all local ordinance or laws. Implied preemption, on the other hand, occurs when the legislature fails to use express preemptive language in a statute, but its desire to preempt is inferred from the declaration of a policy why it decided to pass this law, or from its enactment of a comprehensive and detailed regulatory scheme in that particular area. As most of us know, we have a section of the New York state law called the Environmental Conservation Law. Article 23 of the Environmental Conservation Law deals extensively with oil and gas drilling and development, and specifically reserves to the state the authority to regulate gas drilling and development. We're going to look at it in detail. Article 23, with one minor exception, regulating roads. Actually, when you read the statute, it says the only exceptions are regulating roads and taxes. But taxes have also been taken away. Now the Department of Revenue does that. So all we're left with, the only exception, is local roads. Does not give a town any authority to enact or adopt local laws to regulate or prohibit gas drilling. All right, now when we look at the law out there, the case law, New York courts have addressed this issue of whether local municipalities have the right to regulate oil and gas activities. In Envirogas Incorporated v. Town of Keatone, the New York State Supreme Court, the lowest court in New York, invalidated a town's own zoning ordinance requiring the payment of $2,500 compliance bond and a $25 permit fee for oil and gas wells due to the preemptive provision of the Environmental Conservation Law. So we do have a lower court case in New York where it held that a town's imposition of a compliance bond and a permit fee was invalid because it was preempted by the Environmental Conservation Law. Now, a lot of people don't talk about this particular case. Now, in Envirogas Incorporated, the court interpreted the express preemptive provision of the Environmental Conservation Law, this section. This is the section in the law. The provisions of this article shall supersede all local laws or ordinances. Well, that's pretty darn broad language. relating to the regulation of oil and gas and solution mining industry, but shall not supersede local government jurisdiction over local roads or the rights of local governments under real property tax law. Okay, so basically what it's saying is, according to the statute, the state has a right to regulate oil and gas activities, except they'll allow municipalities to weigh in on roads and taxes. Now, when you look at statutory interpretation principles, typically when a law says that it is taking over an area law, and then it accepts two things, the courts look at that and they say, because they've accepted those two things, if other things aren't mentioned as being accepted, then they're not. You know, if I say to my girls, I say, you can't have ice cream, you know, here I'm going to rule the refrigerator, and you can't have ice cream. Under statutory interpretation principles, if they come up with cheese curls, they can have them, because it wasn't listed explicitly. And that's how courts look at this. Okay, so really, they're going to look and say, are you regulating roads or taxes? If you are municipalities, we're going to listen to you a little bit more. But other than that, no, we regulate at the state level. Now, in reaching that decision, the court said the mere fact that a state regulates a certain area of business does not automatically preempt all local legislation which applies to that enterprise. But where the state law expressly states that its purpose is to supersede all local ordinances, and it did, then the local government is precluded from legislating on the same subject matter unless it has received clear and explicit authority to the contrary. Exactly what we just said. If the law says that the state is going to regulate oil and gas, the only thing that a lower government can regulate is the clear and explicit things that are laid out. And in this case, when we look at Title 23 and the exemption, there were only two things. All right, the court found that the environmental conservation law expressly states that it preempts not only inconsistent local legislation, but also any municipal law which purports to regulate gas and oil well during drilling operations, unless the law relates to local roads or real property taxes, which are specifically excluded by the amendment. Now, this language right here, this regulate gas and oil well drilling operations, when we look at the Dryden decision and the Middlefield decision, that's where the gray is coming in. Because the proponents of bans and moratoriums are saying, our regulation, we're not regulating. A ban or a moratorium is not a regulation. All right, now to me, if I was a dairy farmer and somebody came up to me and said, you can't milk your cows anywhere in our town, I don't know, I would feel, personally, I would feel like that's the ultimate regulation, you know. But that's what the controversy here is hinging on, is that regulate gas and oil. And we're going to see, you know, that those two decisions are lower court decisions, and you know, this battle is going to continue. It's not over. The Envirogas Court relied in part on the Court of Appeals. Now, the Court of Appeals is the highest court in New York. The Envirogas Court relied in part on the Court of Appeals decision in People to Jesus. There, New York's highest court noted that the source of police power, home rule, is the sovereign state. In other words, the municipalities get that power from the state. Such power can be exercised by local governmental units only when, and to the degree, it has been delegated such lawmaking authority. Again, so if they didn't explicitly say the municipalities can regulate that particular topic, then they can't. Accordingly, there should be no doubt that the environmental conservation law precludes any regulation of oil and gas industry at a local level, including zoning regulations based upon public health, safety, and welfare. Think about it. The state is given the power and the resources to hire the DEC, to hire the scientists. Their job is to protect all of us. And what this is basically saying is the state, because it has the resources, is going to regulate this area rather than have it done on a patchwork town-by-town basis. So, on an overall scheme of things, it kind of makes sense. Now, I know a lot of people might not think that the state's capable of it, but I would argue, do you guys really want to get in the business of regulating oil and gas? If you do, then you should tell your politicians to give you back some of the money you send so you can hire the right technical people to help. I'll take questions at the end. I'll be happy to take any questions at the end. You know, I don't have a problem with it. I just want to get through this. The advocates of moratoriums often suggest that EnviroGas decision may not be binding on other judicial districts in the state. A lot of the proponents of the moratorium and ban say that's a lower court decision. Doesn't have any precedential value on the rest of the state. Well, yeah, until the higher courts say something on it. But what was interesting, that case was appealed, or they asked higher courts to look at the decision. They tried to appeal it, but the higher court said, nah, we're fine with it. We don't want to look at it. In other words, typically, the reason why an appellate court will look at a case is because they think it's problematic, that was wrongly decided. Typically, when an appellate court or a higher court looks at a case and says, no, there's nothing wrong with that, we're happy with the ruling, then they won't take it. Now, obviously, the same argument applies to the Dryden and Middlefield case. It's a lower court case. It doesn't, those cases don't have any, they don't have any say or weight with any other court either. Their presidential value is very low. It's the lowest court in the state. Other courts in different counties don't even have to listen to it. Now, a look at the preemption cases. The case law that has been issued by the Court of Appeals, the highest court in New York, coupled with the fact that it declined to even hear the Keatone appeal, gives strong insight into what the court's thinking, the higher courts are thinking, because they didn't want to hear the Keatone appeal. Advocates of local zoning authority over the oil and gas industries maintain that while industries and municipalities have generally interpreted in the environmental conservation law preemptive language to prevent local governments from regulating oil and gas and solution mining activities, New York case law under a separate ECL provision concerning mining, gravel mining, lends support for local governments to exercise some dominion over the oil and gas industry based on general land use and zoning principles. So basically the advocates of the moratoriums are saying, well, yeah, we got that EnviroGas case, but that talks specifically about the oil and gas preemptive language. But we want you to look at this mining laws. And there's a few cases over here we want you to look at because we think the language is very similar. And by looking at those cases, we can get an idea what might happen in the oil and gas realm. Well, one thing, here we have EnviroGas. It specifically talks about the preemptive language out there. Okay, so let's look at those other cases then. Let's listen to them, and let's look at them. The two cases that they cite are in New York are the Through Run Gravel Products versus the town of Carroll, and Gernal Asphalt Products v. the town of Sardinia. So let's look at those. In Through Run Gravel Products, the Court of Appeals upheld the town's decision to prohibit extractive mining in the AR2 zoning district, rejecting the argument that such a decision improperly impinged on the mining industry. the regulation of which is solely within the scope of the state's regulatory program. The Court of Appeals interpreted the express preemption provision governing mining activity, and this is the section, to allow for limited local zoning authority. So basically, they looked at the mine land reclamation law and the preemptive language and said, no, that language allows the town to zone. Okay, so let's look at it. This is a provision. It says, for the purposes stated herein, this title shall supersede all other state and local laws relating to the extractive mining industry. The same, nearly identical language that was found in the Oil, Gas, and Solution Mining Act, preemptive language. But listen to what this says, the next sentence says. This is the exception. Remember I said they say, we're taking over this area law, so the New York State said we're taking over mining, except this. Well, what does it say? Ooh, the thing, darn thing's working.
Work that.
See where we are.
One more.
One more?
Yep.
No?
I'll start over.
No, you don't want to hear that. That'll be painful for everybody. Where was I? Sorry about this, guys. You like I nuke it or something?
Well, you said you wanted to get through it.
4 or 5.
All right.
Sorry about that.
I need to check to see if I'm paying attention.
Gotta go look up my liability and warranty on this thing. All right, let's look at that exception language. That nothing in this title shall be construed to prevent local governments from enacting local zoning ordinances or other laws which impose stricter mine land reclamation standards or requirements than those found herein. Remember, under the Oil, Gas, Solution Mining Law, it said that the state was going to preempt, take over the regulation of oil and gas, except for roads and taxes. This says the state's going to take over all regulation of mining, except local zoning. So to me, well, that's pretty darn clear. The towns have the power under the exception to zone. The court and through run now. So I mean, I look at that case and I say, well, yeah, they explicitly gave the towns the right. How does that hurt? That shouldn't even weigh into the issue of whether the oil and gas law has nothing to do with it. It clearly accepted that area. The court in Through Run found that the above preemptive provision contained an express exception allowing for local zoning regulation, which prescribes stricter standards than the mine land reclamation activity. I agree with that. It is pretty obvious that when you read this language that the legislature, with sand and gravel mining, meant to preserve a town's right to zone out sand and gravel mining. Maybe it was because sand and gravel mining goes on for years, hundreds of years. Maybe it was due to the fact that sand and gravel, I've never seen a gravel deposit move. When you tell somebody who's mining gravel, you can say, hey, I want you to stop when you get to my town border. With oil and gas, it's not that easy. Oil and gas migrates. Gravel deposits, I haven't seen one migrate yet. Even under a good night. Okay, and so there's reasons, geologically there's reasons why these laws were drafted differently. Because the two subjects behave differently. The preemptive provision governing oil and gas activity provides no such exception for zoning. It only accepts exceptions related to roads and real property taxes. So you have to ask yourself, if the legislature was so clear with the Sand and Gravel Mining Act, why, if the legislature wanted to give towns the right to prohibit gas drilling, didn't the legislature provide a similar language in the gas drilling section? In the gas drilling section, it says we're going to preempt, we're going to supersede all local laws except for taxes and roads. They could have very easily said taxes, road, and local zoning, but they didn't. Indeed, the operative language at the time for oil and gas and solution mining law, this was a provision. The provisions of this article shall supersede all local laws or ordinances relating to the regulation of oil and gas and solution mining activities, but shall not supersede local government's jurisdiction over local roads or the rights of local governments under the real property tax law, period. There's nothing in there that says anything about local zoning. And this language shows the preemptive provisions analyzed in True Run and the environmental conservation law are dissimilar. The preemptive language in the oil and gas solution mining law and the mine land reclamation law are not the same. When you look at them, most of the proponents that give talks talk about this. And those first sentence in both provisions are very similar. But they, for some reason, don't show you this part, the next sentence. Well, because it doesn't support their case. Now, all we've been talking about so far is express preemption. We're looking at what was written on the piece of paper by our legislature. You know, people are often mystified that, you know, why are things so unclear? Maybe it's because you have to hire lawyers to go to Albany and represent. Yeah, maybe you want to stop that practice. I don't know what the answer for that is, but the basic bottom line is that they're poorly drafted. You know, people need to pay a little bit more attention when they're drafting laws. You know, to make me go on the unemployment line, that's what you need to do. The preemption provision in ECL exempts all, now this is the oil and gas, it exempts only regulation of roads and local taxation. This is the mine land reclamation law. Exempts local zoning ordinance or other local laws which impose stricter mine land reclamation standards or requirements. Pretty simple. These differences in the breadth of the preemption language of two clauses are clear. You can just look at them. You can understand why this express preemption, to me, it's not that big of an issue. But let's say, for whatever reason, let's say our courts in New York State say, no, it's not that clear. And they don't buy off on this express preemption language. That's not the end of the story. Now they have to look at implied preemption. Because remember, if not only, the legislature has two shots at this. One, it can write clear language, but if it fails to do that, then the courts will look at what other laws did they pass in that area. Is it clear from looking at those other rules that the state intended to preempt local towns? That's what implied preemption is all about. Because if they passed other laws that conflict with towns passing moratoriums, obviously they wouldn't have intended to do that, right? That's kind of the argument with implied preemption. That's what we're going to look at now. So, however, if a court finds that express preemption is not found under the statutory language, then what? The court can still find that local municipalities do not have the authority to regulate oil and gas industry based on implied preemption. So let's look at implied preemption. The New York State Club Association v. the City of New York is a case, Court of Appeals, highest court, has explained this whole implied preemption. The legislative intent to preempt need not be expressed. Doesn't have to be written in the statute. It is enough that the legislature has impliedly evidenced its desire to do so, and that desire may be inferred from the declaration of policy in the statute or from the legislative enactment of comprehensive and detailed regulatory schemes in that area. So they say, you know, just because the statute doesn't say clearly that it controls this entire area, then we're going to look at the language of the statute. Policy. Typically, most statutes will have a paragraph or two on the policy, what they were trying to do when they wrote this law, what the whole idea of the law is. So we're going to look at that. But in addition, we're going to see whether there is a comprehensive and detailed regulatory scheme in the area. Because if one of those two things occurs, then we know that they intended to regulate that area. Okay, so let's look at that. So there's two ways you can find implied preemption. In this case, it is clear that the legislature has impliedly evidenced its intent to preempt local regulation, including local zoning, of the oil and gas industry for two reasons. First, the legislative desire to preempt can be inferred from its declaration of state policy. So I'm saying when we look at the state policy, we're going to see that you can see the intent there. And in addition, you can see the intent when you look at the scheme, the regulatory scheme that was put in place. So let's look at those a little closer. Here's a declaration of state policy under the Environmental Conservation Law, oil and gas. It is hereby declared to be in the public interest to regulate the development, production, and utilization of natural resources of oil and gas in this state, in such a manner as will prevent waste, they want to do it efficiently, to authorize and to provide for the operations and development of oil and gas properties. So they're saying that oil and gas properties should be developed in such a manner that a greater ultimate recovery of oil and gas may be had, and that the correlative rights of all landowners, and the rights of all persons, including landowners, and the general public may be fully protected, and to provide in similar fashion for the underground storage of gas, the solution mining of salt, and geothermal, stratigraphic, and brine disposal wells. All right, so right there, the policy is that we're going to allow, it's going to be a policy of New York State to develop our oil and gas resources in such a way as not to waste it. And we'll see like things like compulsory integration, correlative rights, those were all put in place into the statute to protect waste. Because before compulsory integration, correlative rights were put into law, the rule on the street was the rule of capture. Whoever takes gas or oil out of the ground first owns it, regardless of who owns the surface. And what that happened when that was the rule of the land is that we had overdevelopment and inefficient development of our resource. Because whoever got it first, even if you had to drill 80 wells on your property, you drilled 80 wells, so you got it first. We didn't like that because it wasn't an efficient way of developing the resource. So this is the whole reason why we developed this case area of law, to prevent that. As stated in the policy of this state, it's a policy of the state to regulate the development, production, and utilization, and to authorize and to provide for the operation and development of oil and gas properties. I would argue that a ban or a moratorium would violate that. Therefore, it is the state's policy to facilitate, not prohibit, gas development. So how on earth can a town's decision to completely ban all oil and gas activities within its jurisdiction not conflict with or frustrate this purpose? That's the whole point of implied preemption. Is that if a local municipality does something that frustrates or gets in the way of a state policy, done. Discussion over. Unlike in Pure Run, where the court determined that local zoning authority would not conflict or frustrate the state policy, because they explicitly said they could zone. and states the statute's purposes in the mine land reclamation law, the same cannot be said for New York's oil, gas, and solution mining law. Because remember, one of the additional purpose was to prevent waste, provide for the greater ultimate recovery of oil and gas, and protecting correlative rights. The reason for the environmental conservation law's broad preemption relative to oil and gas drilling is based on the fact that decisions about where drilling units are formed must be decided on the geology, not zoning. One of the things that you read when you read the Dryden case in Middlefield, the lower court seemed to be drawing a line and saying, well, the towns can regulate zoning because that talks about where the drilling is going to occur. But we're not going to allow them to tell them how, but we'll let them tell them where. All right, that's kind of the argument, right? And basically you're saying, you know, regulating the operation and development of oil and gas, when I tell them where, that's not really regulating. That's kind of the argument that they're making. But what I'm saying is, when we look at the statute, when we look at implied preemption, we'll see that all these rules, this regulatory scheme, is all based on correlative rights, unitization, where are we going to place wells? How can we have a statute that talks about where you're going to place wells, and now you're saying that the where doesn't matter? It doesn't work. Doesn't fly. And the reason for that is because it's a geology. And I think that's where the lower court, doesn't seem to get it yet. But I think in the appeals process, they're going to be hit with that information, and they're going to start seeing why this is important. In addition to the clear express preemption in the environmental conservation, it is also clear that the legislator has impliedly evidenced its intent to preempt local regulation by enactment of a comprehensive and detailed regulatory scheme in the area of oil and gas regulation. Allowing individual towns to ban oil and gas activities in their jurisdictions would directly conflict and frustrate these statutory regulations that detail statewide unitization, spacing requirements, and compulsory integration that have been in place for years. I mean, these laws weren't created yesterday. They've been regulating oil and gas under these rules and this complicated regulatory scheme for tens of decades. And now we're saying we're going to allow the towns to come in and start regulating oil and gas? If that happens, guys, New York's oil and gas law, all the volumes, you might as well just toss them into the garbage can. It's not workable. I mean, that'd be equivalent to me coming in and saying, you know, all that New York State constitutional law that we developed over the last 100 years, put it in the can. We're starting over. The very reason why they have these regulations were back in the 1960s and 1970s. The local towns did regulate oil and gas, and it didn't work. That's why these amendments were made to the Oil and Gas Solution Mining Act, because they realized it can't work this way. And we'll see. I mean, if one town, I have a piece of property, it straddles two towns, and I got one town telling me I got a ban, I'm in a moratorium, I can't do anything. And then I got another town over here saying, oh no, we're into it. How's that going to work? Can I drill underneath your town? Your zoning laws tell me what I can do on the surface. What happens underneath? So could I drill underneath you? Who knows? How about if a town that has drilling wants to put a pipeline through, and your zoning ordinance says, no, we zone out bans on pipelines, regular drilling, horizontal drilling, whatever. Everything. Oil and gas gone. You don't think they're going to sue you? Because your law now affects their jurisdiction. It's one thing for my town to say, I can't have a burn barrel in my town. But if you're telling me I can't do something that affects the nearby town, we got issues. We got towns fighting towns. in addition to people fighting people, we're going to have towns fighting towns. And I don't think that's going to go on long before the state says, enough of this mess. Consistent with its statutory directive, the environmental conservation law contains exacting requirements concerning the location and size of spacing units and the location of well pads. Lower court in Dryden and Middlefield said, no, towns can do where, because the state, well, guess what? The state statutory plan talks about where. So we got some problems. We got implied preemption problems. Because these town rules are going to affect and frustrate New York law. Any suggestion that municipalities can regulate the location of oil and gas wells or exclude oil and gas extraction in any portion of a municipality directly conflicts with and frustrates the purpose of the comprehensive statutory scheme in the environmental conservation law. If a court doesn't find implied preemption, we're going to have a lot of issues. Can a landowner with town and land in two jurisdictions drill under the town? What happens if one town bans, inhibits pipelines or drilling in another town? Will towns be suing towns? I mean, people say, you know, these landowners and are just threatening all these lawsuits. Well, we'll see. There are all sorts of lawsuits out there. And nobody's threatening anything. We're just purely trying to educate the town boards that before let's look at this. Don't go running off without half the information. As stated, the comprehensive regulatory scheme makes it clear that well siting should be based upon geology and environmental considerations, not local zoning. This is for good reason, as gravel and oil and gas deposits do not behave similarly geologically. Simply put, I have yet to see a gravel deposit move. Gas deposits, on the other hand, can and often do migrate. When gas that lies underneath the state does move, it usually doesn't respect town borders. Indeed, the environmental conservation law's comprehensive regulatory scheme has been designed around the fact that oil and gas can migrate. It does not respect municipal boundaries or, for that matter, zoning districts. In the end, my opinion in the end, the EnviroGas decision, which addresses zoning within the context of oil and gas industry, not Prue Run, is likely to be the operative precedent in New York. Now, I'm a litigator, trial attorney. I never say 100%. I'm not that foolish. Law is not that black and white. You never know how a court's going to decide. Look what happened in Pennsylvania. The highest court in Pennsylvania said that the zoning was allowed. Well, then what happened a month later? The legislature knew it wouldn't work, so they changed the law. Took it back away from the town. You know, if it gets really ugly, the federal government will step in. The environmental conservation law includes express mandates to promote the full recovery of the resource and prescribes in detail the location and size of spacing units and the location of well pads. The analytical framework of Prue Run actually supports, you know, most of the proponents of bans and moratoriums say that the Prue Run supports their position that allows towns to place zoning law to regulate out oil and gas. I would argue that Prue Run actually supports the other position when you look at it, because it has an express exemption. Without that, that case would implode. So it actually, Prue Run actually supports the conclusion that municipalities are preempted from asserting zoning authority over oil and gas drilling activities because any such effort would conflict with and frustrate the purpose of the detailed statutory scheme set forth in the environmental conservation law. We're getting done. We're getting close, guys. Bear with me. All right. These are kind of my takeaways. So, you know, in conclusion, we look at it. We looked at the express language of the statute, and at least arguably you could see where a court could find that you've been preempted. you look at the two different avenues of implied preemption. One, you know, the statutory framework. The other, both of those seem to apply. So at the very least, I'm saying this isn't clear. It's far from clear. I mean, we got an issue here. And typically, whenever you got an issue in the law, it's usually resolved through litigation. Like it or not, that's what happens. Regardless of whether you buy off on my analysis or the lower court's decisions, you know, they've got a lot more wisdom probably than I have. I'll grant them that. Two things are clear. The legal issues that are complicated, and it's very likely that the Dryden and Middlefield cases will be appealed and litigated further. The fact that those two cases came out, that's not the win, guys. The game ain't over. The litigation will it'll probably take 2 or 3, maybe 18 months, 2 years to decide that the preemption issue alone. And significant legal fees will be spent before the state's highest court issues a definitive decision on the issue. And I guess the big question for the towns is, do you want to open your purse up and your taxpayers' money to foot the bill? Or do you want to just let Middlefield and Dryden do it? I guess that's, to me, is one of the bottom lines. The advocates of the moratorium argue that it's imperative that your town passes a moratorium as soon as possible. And prior to the DEC lifting their moratorium and issue permits. They're basically saying that, no, if you don't do it now, man, they're going to come in here and they're going to drill you. And then what are you going to do? Well, let's look at that. Let's look at that. I would argue that it's not likely to see drilling anytime soon for several reasons. Not only am I going to suggest to you that you're probably not going to see that happen, your risks of putting in a moratorium are going to be bigger than your risks of having 1 or 2 wells drilled in your town. Because those you can always deal with as non-conforming uses and stop the practice after that, after the Dryden and Middlefield cases are decided and you know for a clear fact that you have the power to zone these things out. Did I just hit that accidentally, you guys?
He did.
Sorry. Somebody's messing with me. All right. And I would argue that it's not likely to see drilling anytime soon for several reasons. First, while the Dryden and Middlefield decisions, now remember also, we have the Middlefield and Dryden decision. We also have Senator Seward and other senators proposing home rule legislation. Now, if that legislation is passed, guess what? These cases, courts will say, here, take your papers and go home. Because we don't have to decide this issue anymore. The law has changed. All right, so while the Dryden and Middlefield decisions and any proposed home rule legislation are pending, it is unlikely any gas company will spend millions on delay rentals only to have a town board take them away. Think about this. I mean, why would a town or a gas company come into your town when it doesn't even know whether the band that you're whether they could come in and spend millions of dollars leasing up all your land, only to have a town board 3 months later pass a moratorium and ban and say, party's over. They just wasted millions of dollars. You think they're going to do that? I don't think so. That's why they're going to Ohio and Pennsylvania. You know, the mere fact that New York's talking about bans and moratoriums and home rule legislation is cause gas companies to flee. And new town boards down the road might be a great thing to jump on any bandwagon you want right now. But when the towns dry up and die because there's no economic development, people might be singing a different story. All I'm saying is, let's be rational here and collect the data and make a wise decision. So one, even if the mere fact that bans and moratoriums are being discussed and home rule legislation is out there, I don't think you're going to, listen, I'm an oil and gas attorney. I negotiate oil and gas leases on behalf of landowners. I know the gas companies aren't anywhere near us. You know, I'm going bankrupt. I'm gonna have to go and work for the gas companies. Because these guys aren't gonna get any money for leasing their land anytime soon. 2, as it stands right now, it is not known by anyone whether the DEC has plans of lifting the current moratorium and issuing any drilling permits. So we don't even know now. We already have a moratorium that already covers the entire state. Oh, now we need another one? For every town? Do you really? Yeah, the DEC themselves say that even if we turn on the green light and say New York's open for business, that it's likely that not any more than 75 wells will be permitted in the first year, and then we're going to slowly ramp it up. So, I mean, you think that this area, geologically, is so superior that they're going to be rushing your borders? Believe me, when you look at the geology in New York State, it's a southern tier, the very places where they see the drilling across the border, where they see the landowners across the borders making millions of dollars. They're the ones that are going to get the drilling. They've got better geology. There's a reason why they're drilling in endemic Pennsylvania. 3, upon learning of the now let's say we just wait. Town board just waits. Upon learning of the DEC's decision to lift the current moratorium and the issuance of any specific permit, the supplemental generic environmental impact statement, you know, that 1,500-page document that tells all of us in New York State what they're going to do to help protect us, many people that are making these decisions haven't even read that document. So that's number one thing that all town board members should do, is get that document and read all 1,500 pages. Because how can you tell whether you're in a better place to protect your citizens unless you have read what they've already laid out? But the SGEIS itself says that before any permit will be issued, the town boards will be contacted, and the town boards will be asked to identify areas in their town that have historical significance, cultural significance, wetlands, things that they want the DEC to be aware of before any permits are issued.